4, 3, 2, 1.
Your Honors, good morning.
Good morning.
This is a public panel interview by the Judicial and Bar Council of candidates for the position of Associate Justice of the Supreme Court, Vice the Honorable Priscilla J. Baltazar-Padilla. But before proceeding, we will have first the centennial prayer for the courts, the Philippine National Anthem, and the Supreme Court hymn.
Almighty God, we stand in your holy presence as our supreme judge. We humbly beseech you to bless and inspire us so that what we think, say, and do will be in accordance with your will. Enlighten our minds, strengthen our spirit, and fill our hearts with fraternal love, wisdom, and understanding, so that we can be effective channels of truth, justice, and peace. In our proceedings today, guide us in the path of righteousness for the fulfillment of your greater glory. Amen.
Bayang magiliw, pero sa silanganan, alam ng puso, sa dibdib mo'y umay. Lupang hinirang, tuyang ka ng magiging, sa manlulupi, kita masisingil, sa lahat at bundok, sa simoy at sa langit mo kamay, ay ilang ang tulan, awit sa paglayang tinawag, ang isang ng watawat mo'y nagumpay na nagiging, ang bituin at araw niya kailan papay magiging, lupa ng araw na aming pagsita, layalangin sa likod, aming ligaya dapat may mamagin, at namatay ng tayo sa'yo.
Your Honors, again, good morning.
Good morning.
The panel of interviewers this morning will be the following. The Honorable Chief Justice Diosdado M. Peralta, ex officio chairperson of the Judicial and Bar Council. Probably Justice Jose Catral Mendoza could join us later. He is the chairperson of the JBC Executive Committee and regular member representing the retired members of the Supreme Court. The Honorable Judge Toribio E. Ilaw Jr., regular member representing the private sector. The Honorable Justice Noel Jimenez Tiham, regular member representing the Academy. And the Honorable Judge Franklin J. de Monteverde, regular member representing the Integrated Bar of the Philippines. Your Honors, the candidate for interview this morning is Dean Godfrey M. Candelario. Good morning, Dean.
Good morning. Good morning, Your Honors.
May
Good morning.
I request Dean Candelaria to please raise your right hand so that I can administer the oath? Do you swear to tell the truth, the whole truth, and nothing but the truth in this public panel interview by the JBC?
I do.
So help you God.
So help me God.
Thank you. The first to interview Dean Candelaria will be the Honorable Judge Franklin J. de Monteverde. Judge de Monteverde, sir.
Okay, thank you, Attorney Ed. Dean, good morning.
Good morning, Your Honor.
Yeah, how are you?
I'm fine, Your Honor.
Okay, you're presently the Chief of the Office for Research, Publications, and Linkages of the FILJA.
Yes, Your Honor.
And how long have you been there?
Cumulatively, it started with around 2001, but 1998, I was already engaged on a part-time basis, but 2001, I was designated head of RPLO on a part-time basis, Your Honor, but I was also at that time full-time administrator at the Ateneo de Manila University as assistant and later on associate dean and later on dean of the Ateneo Law School.
You are also an incumbent member of the MCLE's governing board.
Yes, Your Honor, designated temporarily as officer in charge in the absence of an appointed chairperson.
Okay. Now, what is the scope of your work as the FILJA's Chief of Office for Research, Publications, and Linkages?
Your Honor, these are three areas: research, publications, and linkage. Research covers areas where, from time to time, we, on our own, motu proprio, take up some interested issues, no? That may arise, let's say, from current needs of the Academic Affairs Office that normally might spring from questions or need for technical assistance in the development of trainings and seminars. And we also do research in order to fill in our publications like the Bulletin. Bulletin has doctrinal reminders, a collection of current issuances of the Supreme Court, like circulars, memoranda. And occasionally now, we accept some guest writers from the ranks, no? Particularly our judges and even appellate justices in order to inform better our members of the judiciary. And the last is linkages, Your Honor. Insofar as linkages are concerned, we also are able to bring in a number of projects that fill into our publications. Like we have special publications on various aspects of judicial education. And linkage has been one of our windows to project, let's say, receptions. No? The latest, of course, Your Honor, as you might be aware, is that consortium with Spanish, Portuguese, Irish, and also Filipino law schools right now, where the Supreme Court is the only public institution involved in this Erasmus project with the European Union. So that's an example, Your Honor, apart from our usual linkages with the traditional partners like USAID, let's say ICRC on special trainings, and also our link to the judicial education programs, let's say with the legislature and also the executive branch. And I also am part of a series of committees, no, that had actually been instituted from the court itself, no, as a member of the Judicial Academy.
Okay, Dean. Now, as the acting officer in charge of the MCLE governing board, what's the scope of your work?
As part of the board and now officer in charge, my duty is really to one, oversee the operations of the MCLE at this point, and of course, the board is a policy-making body that assists the ranks of the MCLE staff in conducting this so-called mandatory continuing legal education for practitioners, no, and lawyers. That also includes our court attorneys, no, and other personnel who may have need. As part of our function, also we adopt certain rules in order to implement the MCLE trainings. The latest of which, Your Honor, again, as you may be aware of, is how to cope with the current pandemic.
Yeah.
And therefore, we have online. We now have online MCLE, which is most welcome. So,
And do you have a
policy
schedule for that for this year?
yes, Your Honor. In fact, one already offered ahead of probably four others are coming on board very soon in order to cope with the deficiencies of those who may have been unable to attend during the last year.
Now, in your intent letter, Dean, you mentioned that you were given the mandate by Ateneo Law School Dean Cynthia Rojas del Castillo to implement the novel requirement of a Juris Doctor thesis for every Ateneo Law School. What is this Juris Doctor thesis about? Is
Uh,
this different from the Bachelor of Course degree offered by the other schools?
Your Honor, we make a distinction as we adopted it from the U.S. Juris Doctor program. The similarity is that this is a first degree in law. However, when you compare it with other disciplines right now, it is really a postgraduate, let's say, education, similar to med school, no? Because we require someone to have the pre-law requirement. As a Juris Doctor, I think the innovation that was envisioned earlier by Dean Eduardo de los Angeles, no, and subsequently implemented by Dean Cynthia and myself, is the thesis program, where as early as 1990, Your Honor, the Ateneo laid down, I think, what would become the benchmark for a Juris Doctor program, and that is a 50-page thesis for every graduating student. Aside from that, there were initial, of course, offerings called electives. No, we branched out to specialized fields. Sometime in third year or fourth year, at the early stages of the elective system, Your Honor, of course, we relied on the splintered courses initially until specialization had come in to the law school where you have various aspects of law now being practiced. And now it has expanded. We now, in fact, branch to specialized fields. No, you may want a student to go to intellectual property, environmental law, human rights law, corporation, international business law. Those are now what we call a tracking system, Your Honor, which we enhanced during my term as Dean of the Law School.
So am I to understand then that a thesis now is required for every Ateneo Law School graduate before
Yes.
he graduates?
Yes, Your Honor. That was the condition sine qua non at the time we adopted the JD program. The bar confidence said that every Ateneo student, as early as that point, would not be considered a graduate of the Ateneo unless we show proof of thesis compliance.
So he will not graduate until he submits his thesis and he finalizes his thesis program.
Yes, Your Honor, and that's a principal requirement also now consistent with the bar confidence appreciation of our law degree.
Okay. You are still the dean of the Ateneo Law School.
No more, Your Honor. I retired in 2018 and I shifted on a full-time basis as chief
Good job.
of the Research, Publications, and Linkages
Good.
Office.
Okay, during your deanship, did you or were you able to introduce some reforms in school,
Um,
in the School of
um,
Law, Ateneo?
well, Your Honor, I tried to, of course, look at the past programs and I enhanced particularly our JD curriculum. As I mentioned, we introduced the tracking program where a student now chooses at third year what sort of specialized fields he or she may wish to pursue by third year and fourth year. I also enhanced the departmental system of the faculty. We organized the faculty into the 8-bar subject uh, lineup and also electives. No, so that one on faculty development was quite important in order to reinforce our curricular offerings. I also engage in formation of students, Your Honor.
Okay.
As a Jesuit institution, we embark on improving the quality of involvement of our students in and out of the law school, particularly on social programs of our students.
So from there, what can you consider or what would you consider as your greatest achievement at the Ateneo during your
I,
deanship?
I think the impact of the curricular development through the tracking system, Your Honor, is something I can cite as a major development for the Ateneo.
So during your time, you were also a member of, or if not the chairman of the Ateneo Human Rights Center.
Your Honor, I graduated from being a member, active member of the Human Rights Center to a senior consultant because I assumed more functions as dean. No, but for a long time, I was with the Ateneo Human Rights Center. I started, in fact, my practice through the Ateneo Human Rights Center, engaged in public interest litigation. No? Catering to vulnerable groups. That's where my practice has been really as a lawyer for a long time.
And what are the kinds or what were the kinds of programs that you handled or accepted during your administration, especially centering on the Human Rights Center and Office of the Legal Aids?
Your Honor, I think I can cite some of the vulnerable sectors concerned. We embarked on a very huge project on children's rights. We also evolved into handling indigenous people's rights, which in fact was the subject of a test case in Cruz versus DNR as far back as the late 90s, no? On IPRA. We also handled refugee cases, which again also blossomed into some of our extended work for Vietnamese asylum seekers. No? We also handled labor issues, farmers, fisher folk, women also through one desk. We put up a women's desk at the Human Rights Center. And of course, we tried to evolve more in the area of business and human rights, trying to look at the economy and how human rights can inform, I think, standard setting on the economic, social, and cultural dimension. So we are guided in fact, Your Honor, by the fundamental instruments on human rights as implemented by our government.
Dean, you were also a consultant of the GRP panel for peace talks with the Communist Party of the Philippines, NPA, NDF.
Yeah. Yes, Your Honor, this is one of the longest involvement also that I've had outside the administrative work. We
How
start
many years were you involved in it?
when the formal peace talks opened during the Ramos administration, Your Honor, 1995. It opened in Brussels, and I've stayed on, except during the period when I was full-time dean of the law school from 2012 to 2018. But I have risen to a panel member, in fact, under the CPP-NPA government negotiating panel.
So you must know my relative, Inday Santiago, Irene,
Yes, of course, Your Honor.
about from
We
Davao.
we worked especially on both the CPP-NPA and shortly when I was consultant to the government negotiating panel for the Moro Islamic Liberation Front. And she's a very capable uh, women's rights advocate, Your Honor.
Having been involved for many years with the GRP, can you tell us the different approaches used by the different presidents that you had worked under
Mhm.
in
Uh,
dealing with the leftists, and what were some of your recommendations, if any?
mhm. Your Honor, as part of the initial team that handled the drafting of human rights and international humanitarian law, when we were convened back in Brussels, no, together with Ambassador Howard D. under President Ramos. Uh, the peace talk started on a very good, I think, note, which is the drafting of the Hague Declaration, which outlined four major agreements, Your Honor, particularly human rights, social economic reform, political and constitutional reform, and the end of hostilities. This is like a template, Your Honor. In peace negotiations all around the world, you would have such a template. And that was the, I think, the landmark policy that President Ramos was able to pursue in order to reduce the violence on the ground. I think President Ramos at the time rightfully started with the peace negotiations and with the able leadership of Ambassador Howard D. After President Ramos, of course, it continued on, and I think the problems, of course, sometimes are extraneous, Your Honors, no? Because peace negotiations can actually be sometimes affected by policies like entry into the visiting forces agreement, and this is what, to a certain extent, troubled a bit the Estrada administration when the parties on the other side, the CPP, NPA, NDF, of course, were quite worried about the impact of BFA coming into the country. No? So there was a time when that became a very difficult piece of instrument, no, to deal with in the negotiations. And then, of
Okay.
course, President GMA re reopened the talks in 2001 in Oslo, Norway. And that is, again, another milestone, I think, when we started, of course, no, dealing with the issue of peace negotiations. But the GMA administration also had some difficulties because of the issues on extrajudicial killings. No? As you note, Your Honor, that was quite pronounced even when Professor Philip Alston visited the Philippines, no, to do a fact-finding mission in this regard. That became quite problematic. The I was not privy to the Aquino administration process as I was in the law school, and President Duterte reconvened in 2016 some negotiations with the CPP, NPA, NDF, and I think one of the most important achievements of the early part of the negotiations under the present administration was the fact that the president accommodated no less than four members, no, identified with the CPP and KNDF persuasions, no, to the cabinet, no less than the cabinet. I think that was a concession that was quite remarkable. No, it never happened for a long time in the peace negotiations. So if I were to compare, Your Honors, extraneous and also internal preferences by various administrations could make a difference. But of course, the public will always have to be consulted in the long run because it's the public that will be affected.
Now, Dean, the JBC recently issued its revised rules, and one of the changes included there is the mandatory attendance in prejudicature program of all the applicants in the for the judiciary. Do you think exemptions to this rule are necessary? If so, can you cite some?
Your Honor, when we talk about exemptions, and I cite myself, Your Honor, because I applied for exemption, no,
Mhm.
on account of my long time involvement in prejudicature and also designing curriculum for the academy that principally offers the prejudicature. I would think, Your Honor, that given also the opportunity, I personally would have wanted to do it myself, no, because I want to be on a level playing field with the others, except perhaps for certain circumstances that might be telling when it comes to certain persons, no, who may really have direct involvement, and that is where I think familiarity would come in, no. I think the only reason that I tried to apply for exemption at this time is the exigencies of the situation. It was rather late on one hand. The second is, of course, I will have to invoke the familiarity with the various offerings and the design of the program itself, where I am a member of the academic council. I think for purposes also of deference and delicadeza, no, I think it might be worth my while also to invoke it in that regard. But I really would have preferred myself, no, to have gone through such a process if I had been under a different circumstance, because that introduces me also to a broad range of developments, no, in the field of law and practice.
Now, I have gone over your records, your credentials principally, and I must say that uh, my hat's off to you for the impressive credentials that you have.
Thank you, Your Honor.
But then, vis-a-vis the legal practice, you were practically all of your legal life is concentrated or has been concentrated on the academic side, not on the practical one. That being said, how prepared are you for the post in case you will be appointed, considering that theories are practically different from practice?
Your Honor, I mentioned in my application, I recall that I consider legal education and judicial education as two parts of or two sides of the same coin. That's how I viewed my legal education exposure together with judicial education. My legal education was coupled with human rights law practice and some other administrative practices, including test case litigations, Your Honor. If I may just mention quite quickly that I have been engaged in quite a number of test case litigations that reach the Supreme Court, no less. No, for instance, the case of
Briefly.
yeah, the Asia Pacific Conference on East Timor in the mid 90s, IPRA, Indigenous Peoples Rights Act, the Cybercrime Act, also the CINI, impeachment issues, also Legal Education Board, that's Pimentel versus Legal Education Board. And I have also been involved in peace negotiation issues, no? The MOA AD that reached the Supreme Court. Through this and other practices at the Human Rights Center, I think, Your Honor, I could say that I am quite familiar with the process, no? of
You,
constitutional litigation, apart from the mainstream human rights practices.
so you would say that as an academician, you had been properly honed for the post should you ever be appointed,
Mhm.
and that you are prepared for it.
Yes, Your Honor, because I think any basis also for having to go into, I think, constitutional post like the Supreme Court would require quite a broad perspective also on the various branches of law. And that is perhaps where I could come in as a person who has been involved in various aspects. Also, international law is an area that I could hopefully contribute to the Supreme Court apart from constitutional law and human rights law.
You have been twice. You were the examiner for political law and commercial law. Was it?
It's
Am I
political
correct?
and public international law, Your Honor.
Last year you were also the examiner.
Yes, 2010
Okay.
under Justice Carpio Morales, and last year under Justice Teddy Bernardo.
Okay. Now going back to your application, should you be appointed to the post, will there be reforms that you will be introducing?
Your Honor, I think in looking at my experience in the Judicial Academy and having seen training programs, no, I really would be very interested in expanding the capacity of our judges to broaden perspective in terms of judicial education. And one of the things that we're doing at the academy also is to offer opportunities for those in the ranks, the judiciary, to also go into legal education proper. We are hoping if there's a possibility to offer some extended graduate programs for our judges, no, to enhance our curricular offerings, specialized fields. I think it's important to go now into very specialized trainings for some of the courts that have been established, especially on a very technical basis. No, so I would definitely would like to continue with part of the work that I have done at the Judicial Academy, and hoping that the court would consider a committee that will definitely be linked directly to the workings of the Judicial Academy.
Now you are an outsider seeking to join the judiciary. Now what are your chances over those who are already within?
Your Honors, as you have asked me earlier about my involvement with the Academy, I personally would consider myself as partly already within the court for a very long time. My exposure to the workings of the Supreme Court started as far back as the late 90s, and especially when I assumed the post of research publications and linkages head. That exposed me, Your Honor, to the various programs of the court. So there is familiarity on my part on how the court somehow works and operates in various aspects, Your Honor.
Okay. And let's go briefly to your SALN. Specifically, I'm referring to your SALNs of for the years 2010 and 2011.
Mhm. Yes, Your Honor.
Practically, the items there listed are the same. The
Um,
figures, the items, everything, even the total, the total investment, the total as your total assets. Didn't you have any savings, or didn't you earn some money during those period?
Your Honor, my only source of income at that time, since I was not allowed to do much within the administrative field, no, at the Ateneo, when I became bar examiner, if this is one area, was merely to rely on the bar examiner's fee. And
Yeah,
that,
okay.
of course, was not almost equivalent to my regular salary at the law school, where I had to take a leave of absence for 1 year honor. So I definitely was quite restricted, no, for that period, and I think that will partly explain, Your Honor, why there was not much movement on my income level at that time.
Okay.
Mhm.
Now, in your SALN also, from for the years 2010 to 2017, you merely declared your savings, Supreme
Mhm.
Court Savings and Loan Association and
Mhm.
Supreme Court Cooperative. There were no bank deposit in banks or on hand.
Yeah, Your Honor.
Am I correct?
Yes, Your Honor, that's right. That's right. I think
How can you reconcile this with the entry that you made in your PDS that you had
mhm.
a deposit of how much for the year 2010, aside from those deposits with the Supreme Court Savings Loan and Association?
Um, Your Honors, what I can actually refer to, if I may just go back to the SAL and
Okay.
I think there was an explanation that I submitted in regard to the rise in 2012 to 2013, no?
Yes, there was,
But
but
before
I
that,
need to know
yes, Your
right
Honor.
now.
Of course, I was starting with my, I think this was the time I started with Philja at the Judicial Academy.
Okay.
And of course, part of my salary was very menial salary here at the academy because I was not full time. I was full time at the Ateneo, but as an administrator, no. I was also raising two kids at the time at the Ateneo, and I'm the only breadwinner at that time. And of course, my income I was not yet dean for that period, no. So I would attribute part of my I think lack of savings to the fact that we were maintaining the family expenses on the basis of my sole income, no, generally from the Ateneo. Although the partial income I gather from the Philja may really have not been as much, no. It helped in trying to put the bill for the regular expenses that we have. Aside from that, we were also renting just my own room in my parents' place for a while at the city because my children had to be transferred to the Ateneo at a certain point, Your Honor. But I
Okay.
think when better days came, you will see the change in my compensation level, especially when I became dean of the Ateneo Law School. That really helped me a lot for some time.
Didn't you have any savings in the bank for the years
Um,
2010 to 2017, considering that it was only in 2018 that you had an entry in the your SALN as to bank deposits?
in regard to my own account, Your Honor, we were just maintaining what we call a open door account at the Ateneo, where my salary goes into my account, and that's immediately withdrawn for footing the expenses for the family. So that's really not a savings account in that sense, but similar to what we have here at the Supreme Court, where Land Bank becomes your open door account, no, and that's immediately withdrawn. So I think that explains why I really do not reflect it as a savings for that matter, because that's a moving account that almost immediately, I turn over to my wife, Your Honor.
Okay. Now, on current events, Dean, the Defense Secretary, Delphine Lorenzana, just last week,
Yes, Your Honor.
ordered the Presidential Security Group to explain the use of a Chinese developed vaccine against COVID 19, which, according to him, was smuggled because it was not FDA approved. Other health officials said that even if the vaccines were donated, they should pass through the Health Department office and the FDA for approval. It turned out that the vaccines did not have any approval from the two agencies. What are your thoughts on this?
Your Honor, insofar as state regulation is concerned in light of the pandemic, I would defer, of course, to the standards that our health officials, and as emphasized by the Secretary of Defense, no? Was it DILG or Defense that you mentioned? Um, about the standards that have to be met. I think on a level playing field, we have to respect the regulations, and it is also for the protection, especially of those who would have used that particular vaccine in this regard. So, if we really want to disseminate a vaccine that is acceptable and not threatening to the health, I would defer to the fact that any vaccine, no, and this is a factual matter, of course, on the other hand, no, that has to be looked into, must actually pass through the regulatory bodies, because that's our only way of guaranteeing acceptability of standards of vaccines. And this is also uniform around the world, Your Honor.
Okay, Dean, my last question. What kind of a leader would the Supreme Court need now that the present Chief Justice had already announced his retirement in March? What do you look forward in terms of work and court management from the future CJ?
Your Honor, let me first commend, of course, the incumbent Chief Justice for having set the trend, no, for introducing a lot of procedural reforms in our system, because in the manner that we have seen, training programs also give rise to issues on delays in the litigation process. I think the incumbent Chief Justice set the tone for procedural, I think, changes. And I'm hoping that we can still see some procedural reforms in the other aspects of, let's say, criminal procedure in particular, no? If that is an area that might be a priority for the next Chief Justice. The other one is, I think, seeing the capacity of the court to maximize the gains, and I say gains, during the pandemic, because we have discovered the use of Zoom, online meetings, abbreviation of, let's say, travels that will entail huge expenses, especially for PhilJA, Your Honor. We realize that while the pandemic may have caused us to be restricted in travel, we have reached more people through the training programs. And this is where capacity building is going to be very relevant for the court in general, because even the latest adoption of the rules on video conferencing would facilitate a lot of, I think, constraints on the part of the public, no? Especially the poor, who may have need of access. No? I think this is where the court should make it more available in order to reduce the expenses of litigation. But I really think capacity building in the area of technology, information technology, will bring this court really on a very important future mode of litigation.
Okay, Dean, that was my last question. Thank you for your time and good luck.
Thank you, Your Honor. I appreciate
Yeah.
your observations and
Yeah, you stay safe. You stay safe.
thank you, Your Honor.
Thank you very much, Your Honor, Judge de Monteverde.
Thank you, Attorney Ann.
We now give the floor to Honorable Justice Noel Jimenez Tiham. Your Honor, please.
Thank you, Attorney Ann.
Good morning, Your
Uh,
Honor.
Good morning, Dean
Good morning.
Candelaria. I have known you for many years. You are, in my opinion, you are qualified for the Supreme Court. You have trained many lawyers and many judges. But I have to ask you questions for the benefit of the other members of the council.
I would appreciate that, Your Honor.
Dean Candelaria, you sit in the MCLE governing board up to the present. Uh, in your opinion, how do you raise interest on the part of lawyer participants in the MCLE? Because I noticed when I was active in the MCLE lecture circuit, I noticed that some lawyers, especially the older ones, would just go through the process of
Mhm.
attending MCLE
Yes.
lectures.
Mhm.
How would you raise more interest, especially in this period of pandemic?
Thank you very much, Your Honor. I think this is a perennial problem that has been raised at the board. And a few years back, when I was assigned by Philja to represent the academy at the board, this was one of the lingering issues that we had to cope with even before the pandemic. Let me just say, even before the pandemic, I think one of the mechanisms of having to attract the more senior ones, no, to be dragged, no, literally be dragged into these training programs, is the kind of offerings, no, that providers would lay down for the participants. So interest would really be developed through the kind of curricular offerings of the providers. No? That requires us to study further our participants. No? Where are the participants coming from? What are their stages of, let's say, practice or non-practice, in fact, no, for the others. No? How do you make it more interesting? And this is where specialized areas also could be tapped for purposes of enticing them to come on board. The other one is physical, Your Honor. I think the face-to-face trainings that we've had also, uh, comparing now in the pandemic, really was tedious, Your Honor. Just to be in a 3-day seminar, pulled out of your law practice, that really is something that has to be studied. No? And if you want to make good use of your time, it has to be an attractive program. Speakers in particular, no? Speakers who do not repeat what they have said for the last compliance period, no? And we have seen quite a number of that in the early stages, no? First compliance is still being said here up to this point. There must be graduated program in curricular offerings. Now, turning to the pandemic, as I just answered earlier, Your Honor, we can capitalize on the technology that has evolved. It may be a little more expensive at first, but if you have more providers coming in doing the online, those who had to be literally dragged to the training programs in the past and now familiar with technology, a little of the technology, no, if they're given that provision, will have to stay in the comforts of their home to do it at their own pace. No? That I think is the greatest contribution that we have introduced this time at the MCLE board, and which we hope, with the support of the Supreme Court itself, no, could be enhanced, no, by the reinforcement of the rules of the MCLE board, because I think we discovered something that really will maximize the time of people in this continuing education program.
You have no objection to videotaping the lectures of MCLE lecturers and making the same accessible, easily accessible to the lawyers, uh, and they will just pay to the MCLE provider and then connect to the link and given the password, and then attend the lecture at their
Uh,
convenience.
Your Honor, in the latest rules that we have endorsed to the court for approval, as you will note, there are certain standards that we have to look into the provider's practice. No, for example, like the identification of the person, and also the manner of gauging whether that person had appreciated, let's say, a module, no, that was online. You have pop-up quizzes, no. Of course, in a face-to-face setting, you can ask questions right away, no? But in an online, we have to require the providers right now to do some pop-up quizzes. It's just like learning in regular law school, for example, or education, where you have to validate that the person learning online is able to appreciate. Of course, there are still some pitfalls every so often, but I think we have to also provide a guarantee that the person who is using it is the same person. Otherwise, we will have that problem of monitoring. So the provider now becomes principally a monitor together with the MCLE board, no, for that purpose. But yes, the answer is it is convenient to do this system in order to address also the logistical and I think the schedule problems of practitioners.
Do MCLE providers administer evaluative written examinations to
Um,
participants, just like in the FILJA?
there are options, Your Honor. No? As I mentioned, the short quizzes in between can be a check, and the other one is a written exam. Some providers had already broached the idea that it might be worth their while to get the participants to write out, no, some kind of an extended type of answer or evaluation. And we now have tasked the providers to do such an evaluation in order to gauge again the knowledge acquired and appreciated by the participant.
Now, Dean, you are from the academe, and I'm a member of the JBC representing that sector, and you have been a bar examiner many times. In your opinion, and without preempting the final action that the chairman of the bar committee, Justice Marvick, will do actually this year, how do you foresee, how different will the bar examinations be, in your opinion, and how you look at it compared to the bar examinations last year and the previous years?
Um, Your Honor, I'm excited on one hand, no, because of the innovation being introduced and the fact that I have seen, I think, through some other models of testing, let's say, capacities of examinees, no, using online. So in that regard, it's most welcome, Your Honor. The only challenge, of course, would be the kind of access that they would have, no? Because there are extraneous factors, for example, that will have to be guaranteed when it comes to online, no? And which probably may not be within the control of the Supreme Court per se. And I'm talking about those telcos, no, that will provide that access, no. We are probably going to be challenged by those, assuming all other things being equal, that we have a very fine system of internet access. No? That is really the trend in the future. Number two, it facilitates checking. Checking will become very much easier from here on. As you said, and you have been examiner. I think more than once. I think it's tedious to be checking booklets, no? And 15,000 is not a joke next year, no? And therefore, the technology, I think, will adapt to the challenge right now. But it has to be very secure, Your Honor. Just like what we do in MCLE curriculum design, we have to be very, very circumspect in the kind of, let's say, security measures that will be taken here. Access to the information, hacking issues, no? Those are, I think, some of the challenges, and you will require a very thorough consultancy arrangement, no? To be able to look at the various nuances that may happen on the day of the exam itself. Um,
Separate venues will become a reality as announced
yeah.
by the High Court. In that sense, it would be expedient to solicit the assistance of the Integrated Bar of the Philippines
Yeah.
in monitoring
Uh,
the actual examinations, or probably even the various courts
mhm.
nationwide. So it will be easier. Is it, would it be impractical to conduct the bar examinations inside the campuses of schools nationwide? Will that be impractical?
Um, I think it might be useful to look at the school settings already, Your Honor, because they're built in. Even the infrastructure itself, I think, would be convenient. No,
Yeah,
you just have to be able to again handle security measures. No,
correct.
because
Because even the traditional venue is in UST
yes,
or MLQ before, and it's in a school setting.
yeah, yeah,
All you have to do is to employ unbiased monitors, correct,
yeah.
to supervise the examination. So that is something that can be done. Now, my other question, Dean, is you're from the academe. When you join the Supreme Court, you will
Mhm.
be in the company of justices who also came, or who also came from the academe, just like Justice Leonen, even Justice Bernabe, Justice Esmundo. As a magistrate, will you be more discerning on the issue of the constitutionality of the law by looking into the defects of the law, on what the law should have been? Will you have that kind of frame of mind as a magistrate?
Your Honor, of course, we don't want to go into judicial legislation, but I think part of the function of the Supreme Court really is to declare whether a law is in conformity with the Constitution or not. In that regard, I think I am of the view that the function of the Supreme Court definitely is a vanguard of the Philippine Constitution. And to that extent, I think it's very important as a magistrate not to be restricted, no, by any form of persuasions in order to see the law in its very pure form in relation to the Constitution. So I would be one with especially the academics in the Supreme Court now sitting that it's important to scrutinize the law from a very academic perspective because it broadens your view of how a legal system should actually be working in relation to the Constitution.
Is it constitutionally permissible for magistrates in the High Court to assail the constitutionality of a law sua sponte, even if it is not raised in the pleadings, if it is in the minds of the magistrate unconstitutional?
Um, we have, of course, the constitutional practice of having to make observations on the side, of course, no, that may be done by some justices in the past, no, who will make observations. But I really think that as far as the court is concerned, the function of the court is simply to declare whether a law is constitutional or not. And to go much further than that, I think I probably would leave it to the other branches of government to deal with the enhancement or reinforcement of a legislation that may have been declared not in conformity with the Constitution.
Do you adhere to the principle of constitutional avoidance? Meaning to say,
Mm.
not to look into the constitutionality of an issue or of a law if it can be resolved on some other grounds?
Um, Your Honor, one of the standards that we follow in judicial review is that the constitutionality must be the very least mota itself. No? And it's important for us to observe that. Otherwise, we might go into the realm of uncharted waters that may bring us closer to the so-called non-judicial function of the Supreme Court in that regard. There are, however, as we have seen in some cases, exigencies. No? When because of the issues raised, it may be important to somehow lay down an observation, but not to the point of having to treat it as a full-blown constitutional concern. So I would be indifferent still with regard to probably a later case that may bring it up, no? Unless there are contingency issues and exigent circumstances that will require the court to take it up on an existing litigation before it.
Now, more than 30 petitions were filed before the Supreme Court assailing the constitutionality of the anti-terror law. If you sit in the Supreme Court as a magistrate, what questions will you ask of the petitioners before you can resolve the issues brought forth before the court? And on the other hand, what questions will you ask the respondents before you make an adjudication of the case?
One of the traditional tests or steps taken usually by the High Court on matters of constitutionality of a law is to find out whether there is a pending case itself. There is a case that brings forth the constitutional issues. No? Because that's from the point of view of the Supreme Court an important matter to consider in order to direct the court's attention to a very specific factual issue where constitutional concerns may be raised. Otherwise, the court might go into the realm again on uncharted, unreigned navigation through a very voluminous legislation or a very intricate and I think controversial legislation. So it's important to focus. That's the first, I think, question that may be raised. No? Why should the court entertain your petition? Is there an issue that has been raised, in fact, on a very factual basis? Otherwise, it will be just speculative in character. It might even be, at that point, just hypothetical. So that's important, I think, on the part of the petitioners to understand. For the respondents, on the other hand, I think normally the question is the standards that the, let's say, that the legislators, and upon this instance, of course, of the state defending the law, had been actually passed. No, that there's a presumption, of course, of validity on the part of the act of the legislature, and therefore the respondents probably would be properly asked about whether this is going to be merely hypothetical. No? Does the Solicitor General, for example, consider this as hypothetical, speculative? No? So much the same way that I think on a different vantage point, I would raise the question of the petitioner to the respondents in that regard.
Is the claim that the case is of transcendental importance a constitutional excuse for the court to decide factual issues?
Um, there has been a long-standing, I think, practice on the part of the court to narrate the fact that the Supreme Court is not the trier of facts, no, and that standing issues also have been raised, lack of standing. But oftentimes, I think the court in the past and into this day had allowed transcendental importance as an issue that may be argued, no, by the parties, no, particularly petitioners. But transcendental importance, of course, had on a couple of occasions not been worthy to be invoked, no, in certain cases. So the trend, I think, of the Supreme Court has been, while they may look at standing issues or factual concerns initially raised that might throw out the petition, in the long run, because of transcendental importance, public interest involved, national security, for example, and the need to protect citizens' rights, the Supreme Court resorts to the transcendental importance mechanism in order to entertain test cases before the Supreme Court, Your Honor.
By way of first impression, in your opinion, is the anti terror law a penal statute?
Um, Your Honor, I think as far as the anti-terror law is concerned, there are definitely penal consequences and provisions, no, for having to be found in violation or within the scope of the anti-terrorism law.
In that regard, Dean, is a facial challenge available against the anti terror law, which may be considered a penal statute?
I refer back to the president, of course, on Southern Hemisphere, which was the earlier case on the Human Security Act, Your Honor, where the court, in fact, had dismissed such a petition, no, saying that facial challenges are really not a matter for penal statute, and that, let's say, penal statutes by itself or by themselves are really having in terrorem effect, no, and that facial challenges have actually been applied in free speech normally, no, free speech cases, Your Honor. How this anti-terrorism act now will be, I think, argued is a matter for the court to study and look in particular the trend that it has set, particularly on the Southern Hemisphere, no? Whether the circumstances are similar and whether the nature of the law as crafted now would be almost identical with the Human Security Act. But that's as far as I can offer an opinion, Your Honor, in the absence of an actual precedent under the present Anti-Terrorism Act. Southern Hemisphere would be the guidance initially for the courts to consider.
Now, the internal rules and regulations drafted by the executive department through the Department of Justice implementing the anti-terror law, in your opinion, is it necessary to be scrutinized by Congress in the exercise of legislative oversight?
Your Honor, the oversight function of the legislature really is very much limited to seeing whether the law by itself is being complied with, no? An IRR being crafted by the executive branch, Your Honor, is a matter for the executive to consider. If there is anything wrong with the IRR, Your Honor, I think if there is any question about implementation of such law, That's a matter for the Supreme Court to decide on a proper case whether the implementing rules and regulations are consistent with the law itself. But the moment a law leaves Congress, the only remaining task of Congress is oversight. But that is not to change an IRR because it's the Supreme Court that will have the authority to pass upon, let's say, constitutionality or validity of the IRR later on.
In your opinion, Dean Candelaria, is the veto of the president of the budget, which set aside the submission of reports on intelligence funds subject to congressional oversight and review?
A veto, Your Honor, is one that may actually go through the process of eventually, no, the constitutional procedure of whether the House or the budget came from, no, would in fact reconsider or allow that veto in the long run. The overriding of veto is one that will eventually be a process, no, that will go through. Oversight function, of course, Your Honor, is a matter that is separate from the regular process of, let's say, overriding a veto by the president. So those are two distinct processes, Your Honor.
How the intelligence funds is defrayed or disbursed by the executive department, is that subject to the constitutional right of information?
Your Honor, there are matters that have been considered by case law as one that may entail national security issues, no? And this is one that may have been subject of privilege, no, in the past, no? And I think type of information is covered as early as far back as the U.S. versus Nixon case, as we have applied in the Philippines, no? And national security issues have always been one of the matters for exercise of executive privilege, Your Honor. In that regard,
what is judicial independence, Dean? What is your understanding of judicial independence?
Judicial independence, Your Honor, I would distinguish on 2 points. No, one, from the point of view of the institution itself, that the judiciary must be beyond the, I think, the control of any other branch of government, or for that matter, that the 3 branches of government are designed in such a manner that they have their specific functions, no? And therefore, one should not be undermining the other in that regard. But independence also can be viewed from the context of the person of those who are running the Supreme Court, from the very high to the, let's say, first level, second level courts. And I'm talking of the person of the judges, no? One is institutional, the other one is the person of those who run the institutions. So this Constitution is very specific about the separation of powers, the independence. But talking about the person of those who sit, that's a matter that is personal. But that's an aspect also of independence of the court through the personnel running the institution.
In your opinion, Dean Candelaria, does the filing of an impeachment complaint against a magistrate in the Supreme Court threaten or infringes on judicial independence?
A filing by itself, no, in the course of regular procedure before Congress, is a constitutional process. It's one that is available, no, for the citizens to guarantee that the Supreme Court is run by those who are most capable, and in light of the standards of the Constitution, of competence, integrity, probity, and independence. No? And I think that is where the process affirms the fact that those who sit in the Supreme Court and other impeachable officers are answerable to the body politic. No? So it should not threaten any magistrate for that matter, for as long as that magistrate is able to defend oneself in the course of the process. I think it's a prerogative, it's a right of every citizen of this country.
It's a process enshrined in the Constitution, correct?
Yes,
To
Your Honor.
ensure judicial
Mhm.
accountability. Is social justice, in your view, the same as justice, Dean?
Uh, One, of course, is general in the sense that justice can be in different aspects of human endeavor. But social justice has an implication on, for example, the structures of government. Um, the social structures. For example, there are systems within a country that may perpetrate a form of injustice, but contributed by, let's say, conditions of poverty, conditions of access to certain goods, deprivations. So I would think that justice is a general concept, but social justice is more specific when you now refer it to forms of structures within society that perpetrate a kind of condition for the most marginalized persons within a body politic, Your Honor.
In your opinion, will social justice correct or cure social inequality?
Um, Your Honor, there will always be a condition of inequality. Maybe the access itself is what social justice will allow that to happen. However, um, social justice must actually be able to address the very root or source of the inequality. I'll give an example, Your Honor. In the course of the peace negotiations that I have been to for the last so many years, since 1995, there's always been a very important principle that we gathered in the peace negotiations process. For example, they said, how can we address ultimate equality when the conditions within a country continue to be unequal? We can speak of social justice in a very hypothetical sense, in a theoretical sense, but in practice, are the structures of society reinforcing a condition of access to goods, to services, to health, for example? Because if those are not reinforced, those are not reformed, then we will not be able to even achieve what we call a just and lasting peace. So that's a term that oftentimes recur in the process. No, so I really think that social justice um, will not be an easy answer to what we call absolute equality. Um,
I went to the mall yesterday to celebrate my birthday, and I was barred from entering because existing protocol says that only people between the ages of 18 to 65 will be allowed inside the mall. In your opinion, is there a constitutional or a scientific basis for that? And in your opinion, is that not discriminatory and assails the equal protection clause?
um, well, let me
Because
look.
that means to say some of the members of the High Court will also be barred from
No.
entering public places, and loosely including the president, who is above
Yeah.
65.
Yeah. It's a very interesting situation, Your Honor. I would think that kind of policy, no, if I were to look at those who regulate entry, are coming really from a more protective perspective, no. One might say that that's even affirmative action on your part, so as not to make you vulnerable to what we call contamination of the virus, no. But of course, this is a function of one's health condition at the moment, no. And scientifically, of course, one might broach a different perspective. No? There might be other medical opinions depending on your vulnerability, especially if you're beyond 65. But I'm sure that they are coming from a more benevolent perspective, Your Honor,
But
rather than
isn't 65 an arbitrary number?
well, of course, there will always be a cutoff that they will have to adopt, such as
All
retirement.
right. My last two questions, Dean, is in your opinion, should vaccination be made mandatory
Your Honor,
or against COVID-19?
I think at this stage, it's
And will it be constitutional? That's the other question.
Your Honor, I would like to answer that by looking at the medical reliability also of what is available in the market now, because that's something that every citizen right now is thinking about now. That while I am in a position to potentially infect another one if I don't have the vaccine, on the other hand, there's that concern of reliability of the vaccine, because putting something into your system is something that will eventually be beyond your control in terms of its consequence.
So
And to
there
what-
are human rights issues, do you think?
Yes, Your Honor. But it's a function of reliability also of the medicine. No? So science will have to be an important factor, no, in this regard. I don't think it's an issue, simple
All right.
question.
Assuming that we cannot make it mandatory, we cannot compel people to be vaccinated.
Mhm.
Spain announced that it will set up a registry of people who refuse to be vaccinated against COVID 19, and they will share it with other EU countries. But the list will not be made accessible to the public or to the employers. Now, in your opinion, if the same system is adopted in the Philippines, if a registry of people who refuse to be vaccinated is adopted here in the Philippines, will that be valid and constitutional?
Potentially, Your Honor, if the privacy aspect of that list is guaranteed, no, and it's also for the protection of the general public, of course, no. I would think that regulated access to that information may be acceptable under constitutional standards, no? Provided the privacy aspect is taken into account, Your Honor.
Hungary has proposed the adoption of immunity passports, meaning to say, people who have been infected
Mhm.
with COVID 19 and they have recovered are to be granted immunity passports so they can freely travel around the world because of the scientific belief that if they have been exposed to the virus and they recovered, they will develop antibodies. So they will no longer be capable of infecting or being infected.
Mm.
In your opinion, an immunity passport would be, for purposes of foreign travel, would be valid and constitutional.
Your Honor, again, that's a function of science. No? It's not a simple case of being constitutional or not, but a function of science. reliability of that information, it may still be challenged, Your Honor, in that regard. It may be difficult to accept it hook, line, and sinker at this point, Your Honor. Besides, the right to travel is subject to restrictions also. No? If one country receiving that person is in doubt, no, you cannot enforce that to another sovereign, and therefore every sovereign will have to assess it on the basis of its appreciation of its impact of this person's entry into one's jurisdiction.
All right. Thank you very much, Dean, and good luck.
Thank you very much, Your Honor. Appreciate your questions.
Thank you so much, Your Honor, Justice Tiham. May we now turn over the conduct of the interview to Honorable Judge Toribio E. Ilaw Jr.
Yes, thank you, Attorney Ann. Yes,
Good morning.
good morning, Dean.
Good morning, Your Honor.
Can I give you a 30 seconds reprieve?
Thank you.
Can breathe deeply and smile.
Yeah, can I take a sip, Your Honor?
Okay, please. Because I've been listening that questions and answers are so interesting between my colleagues, interviewers, and your good self. I do respect you, but we do not know each other personally, except perhaps that we oftenly meet at the lobby
Yes, Your Honor.
waiting for the elevator, except for that, Tagala. By the way, you said that you already divided your position as a dean in the College of Law Ateneo,
Yes,
and
Your Honor.
you are in full-time basis in the PhilJA.
Yes,
So,
Your
do you
Honor.
consider yourself a government employee or a public official?
Yes, of course, Your Honor. I comply with the regular government requirements, and I do consider myself in that regard inside the court itself. No?
At, and the JBC rules that encourages careerism. Are you aware of this? That promotions are given or preferred to justices, justices and judges, those who belong to the judiciary.
I'm fully aware.
Seemingly, you are,
Yes, Your Honor. I'm fully aware of that principle.
but you consider yourself not a stranger, even when you're nominated and appointed as an associate justice of the Supreme Court. Am I correct?
Yes, Your Honor. As I explained, my involvement has been as far back as the late 90s and early 2000s.
So preference is given to those justices and judges. Why do you consider yourself to be an exception to the rule?
Your Honor, while I may not have risen from the ranks of the judges and the justices, I think my involvement in the various functions and trainings of the Judicial Academy had really exposed me to, let's say, the operations of the court at the first, second level, and even at appellate level. My involvement also is with the specific committees created by the Supreme Court on special topics. And the Philippine Judicial Academy is under the supervision and control of the Supreme Court. And in that regard, I think we are just as much a part of the organic whole of this institution.
All right, my colleagues might have overlooked your medical condition or your health condition because your ECG shows sinus bradycardia and your X-ray results show tortuous aorta. Bradycardia means slow heartbeat,
Mhm.
while your X-ray shows tortuous aorta, characterized as twisted, curved, enlarged or narrowed blood vessel of the heart. Were you able to consult your physician personally or official?
I'm in consultation, Your Honor, with a medical heart expert in Cardinal Santos. That's Dr. Ariel Miranda. No, he has always been for the last several years. No, my heart doctor, and I've done all my other treadmill, ECG, and heart related medical procedures. No, with Cardinal Santos in the past. No, and he said that's really negligible. No, it's not. Besides, I'm a person who has been always athletic, Your Honor. My regular perhaps pulse beat is not the same as the others, simply because of the athletic condition that I also have been in the past. No, but he says that as far as those other findings are concerned, those do not affect anyway my physical condition at this point.
Do you consider yourself physically fit to
Yes, Your Honor.
undertake the duties and responsibilities of an Associate Justice of the Supreme Court if and when you're nominated and appointed?
Uh, I think, Your Honor, with my daily habit of doing exercises, and before the pandemic, I do regular swimming. Early stages of my life, I was also a football player myself. So I've always been athletic in my physical preparations.
You've been a varsity player of Ateneo in soccer,
Uh,
football.
in Lourdes Mandaluyong and Ateneo Varsity, Ateneo de Manila University. And I played in some commercial leagues also in football, Your Honor.
Okay, that's good. What took you so long to apply as a Associate Justice of the Supreme Court?
Your Honor, I have been contemplating of this, especially at the time I was at the latter part of my deanship, no? And I thought that having been able also uh, to look at the rounds of legal education and eventually judicial education, I thought that it's high time to apply at this stage, no? So it took me some time to contemplate, looking at the kind of preparation that needs to be done by someone applying for the Supreme Court. And I truly believe at this point that I may have reached that level of preparation and perspective that will give me, I think, something to contribute to the Supreme Court at this stage of my life.
And this is the first time you're applying as a Associate Justice of the Supreme Court. Can you
Yes.
tell can you tell me something about yourself, which is not found in your application requirements?
Um, I think I can look at my own personal experience as a person, no, which of course may not have been fully covered in the information, and I I believe that I'm a person that am able to associate well with others. No, I'm a team player. I've always considered myself as a team player in the sense that I'd like to be able to reach consensus with people. That's I think a a training or perhaps a capacity I have developed, having been working with so many persons, no, institutions. So I like to build relationships in that regard, relationships that will somehow bridge consensus with the others, no? um, but while doing that, I think I maintain my independence as a person. I am able to perhaps assert my own views and perspectives, and at the same time respect others' perspectives. No? But it's very important, I think, in any type of setting, in any type of work, that one is able to engage others, no, and to be able to see the positive side of people. Uh, that's where I think I may not have said much in my application. No, it's on that very personal note, Your Honor.
Arat, do you think being a magistrate is the only thing missing in your roster of achievements?
Um, Your Honor, being a magistrate is probably uh, more than just an achievement for me. It's a service. I consider it as the probably culmination of public service. When I first entered the Supreme Court as a technical assistant to Justice Benaventura S. de la Fuente right after the bar, I was here in the old building here at Paura, and I thought one day um, it's really good to be part of the Supreme Court. No, as early as that, I had some kind of yearning at that time. But for me, it's service. That's the reason I entered the Supreme Court at that time. Among the three branches of government, I thought that the Supreme Court is one where I could be uh, more appropriate in terms of my temper, in terms of probably my capacity and my preparation, and at this stage in my life. So I'd consider it a service, Your Honor, not just a matter to achieve, but a form of service that will culminate my career.
Oh, why not be a politician or either join the Department of Social Welfare if
Um,
service is the priority of your life?
but I'd like to look at it in my own competence, Your Honor, and my own temper. Politician requires certain temper. Social welfare, of course, while also might be a very benevolent service area, but I think I could utilize my preparation better within the context of the judicial and legal system.
Arat, in your application letter, you stated that, and I quote, "It is my belief that our courts have become a catch basins of cases as a consequence of existing armed conflicts besetting our nation." Could you expound on this further?
Thank you, Your Honor. It's something that I was very emphatic about in my application, simply because I have seen the number of deaths in the course of the armed conflicts in this country, and I'm just not talking about the CPP-NP, NDF, or MILF, but so many other splintered armed conflicts. And the courts often are at the receiving end, Your Honor, of cases. No, eventually judges, no, and other court personnel get to receive these cases of very difficult and complex issues, no, as a result of the armed conflict. That's the background of where I'm coming from. When we were trying to negotiate and look at the cases, no, in relation to the armed conflict, we thought that a track in having to reduce that would probably be to go into final peace negotiations and agreements, because that's a big factor. If one were to reduce not just the fighting or the killing on the ground, but even the kind of cases that eventually visit our first and second level courts, and even up to the appellate and the Supreme Court. So it's a mission that I thought might be worth looking into in relation to the available processes that may be pursued to achieve a just and lasting peace in this country.
And I learned that when asked what will be your contribution to the Supreme Court, you said of giving zero into legal education. What, if any, do you wish to change in our judicial system or process? Aside
Um,
from the existing ones, continuous trial, and the reforms made by Chief Justice with respect to the procedures?
um, Your Honor, I think greater emphasis could actually be given to methods of mediation and actually settling disputes, no, in a very less litigious process. It's a very important skill. I know for some persons to be able to mediate cases, no. But if that can be further enhanced, it will save us a lot of cost, no, and energy going through the rigors of years and years of having to wait for a case to be settled. So I think it's an important goal to enhance the capacity also of this kind of accompanying functions, no, to the mediation center. I've seen that, no, and there is great potential in trying to see some of the most difficult cases, no, resolved. It saves us a lot of logistical, I think, concerns as far as the court is challenged by these concerns.
But these are functions within the bounds of the lower courts, not the appellate courts.
Uh,
Mediation, arbitration.
but I think CA, there's still a level, the appellate level, no? Court of Appeals. There are also opportunities for that. Um, so when one looks at the other aspects of Supreme Court functions, no, aside from first and second level courts, I think it's also important to enhance capacities of those who are actually working around the court system, no? So administratively, I think the court is still given much opportunity to improve our administrative processes, no? And to do this, as we have been doing also with the Judicial Academy, capacity building trainings, no, could complement and supplement the capacities of those supporting the court uh, judges and also the justices, no, in their regular function. Uh, I know that the Supreme Court is not just devoted to decision writing, but there are other auxiliary functions, no, that the court also delves into, and this is where I think the auxiliary functions can reinforce much the decision making activity at the Supreme Court.
All right, from the question and answer, from the question of Justice Tiham with respect to the function of the Supreme Court, dealing only the question of law, and he mentioned about the transcendental issue. In the recent case, the Supreme Court reminded that direct recourse to it should only be allowed when the issue involved is one of law.
Yeah.
And in passing, the court may still choose to avoid passing upon constitutional questions, which are confessedly within its jurisdiction, if there is some other ground on which each decision may be based. Now, the court, what are the guidelines set forth by the Supreme Court in the exercise of its judicial power of review, and what are your thoughts on this, Dean?
Um, Your Honor, yes, of course, in the exercise of the power of judicial review, the court will almost always look into a justiciable controversy that has to be established. There's a justiciable controversy that is to be resolved by the court, and that constitutionality is the very least mota of the case, no? Having said this, I am fully aware of the court's mandate to defer cases to the lower courts as a result of the principle of hierarchy of courts. No? That oftentimes the court invokes hierarchy of courts, which might be a clearing mechanism, no? To avoid any cases that may be purely factual that may go to court. So I am of the view that hierarchy of courts principle continues to be a very good clearing mechanism for the Supreme Court before it entertains volumes and volumes of cases on a mere invocation of constitutionality or unconstitutionality.
By the way, Dean, what is your philosophy on legal education?
Um, through the years that I have been teaching and also doing scholarly writings, Your Honor, I have pursued an attitude of seeing legal education as a tool to to achieve social justice in this country. I think legal education is one that will uh, contribute, no, to a better understanding, not just by future lawyers, but even the citizens at large, no, on how the legal system can serve their purposes in the promotion of basic civil, political, economic, and social rights. Legal education, if also tapped into by even the average citizen, could become an opportunity for them to be at home with institutions, with processes, no? And not make it just a monopoly of those who know the law. Therefore, one of the things that we have introduced at the Human Rights Center in public interest lawyering is to make the legal education and legal knowledge even accessible to those communities that we have serviced or gotten into in the course of our work. That means making those communities aware of their rights, no? And as lawyers and even as interns, our students for a very long time have been doing this, reaching out to communities. That is how legal education must trickle down to the communities, Your Honor. And that is where I believe I have been most at home with and to a certain extent exposed to as far as legal education is concerned.
And how did the court pass upon the constitutionality of the PhilSat? That is in the case of Pimentel versus Legal Education Board, September 10, 2019.
Um, yes, Your Honor. I was privy to some of the proceedings at that time, having been requested to assist the court as amicus on some points of legal education. And I thought that the problem with the PhilSat at that time was the purely exclusionary character of PhilSat. No? Unlike in the earlier case of Tablarin, no? On the NMAT, PhilSat tended to be exclusionary in the sense that one who does not go through PhilSat is forever barred, in fact, from having to be given a chance to access legal education, no, in a law school. So that's one of the main challenges for PhilSat, but making it as a factor in having to admit a student, but not in an exclusionary manner, may still be allowed because some schools who do not administer their own admission exams may just want to use the standards of the PhilSat for their own law schools. But to say that that's going to be uniform around the country, with all the limitations that other law schools would have, might actually deprive, no, deserving students, no, of access to a law school in the long run. That's the meat of what I have shared with the court on the matter of PhilSat, Your Honor.
All right, the court pronounced that legal education is an exercise of is an executive function as it is, but a composite of the entire Philippine education system. It said that the court exercises only judicial functions, and it cannot and must not arrogate upon itself a power that is not constitutionally vested to it, as that will result in a violation of the doctrine of separation of power. Do you agree with that?
Yes, I remember that in the dispositive portion of Pimentel versus Legal Education Board, Justice Jose Reyes distinguished the encroachment on the court's power. For instance, mandatory continuing legal education. That's a matter for the court to consider because we're engaged with practitioners. And Legal Education Board is engaged with those who are entrance to the law school and for the duration of being in the law school, Your Honor. And to that extent, it's unconstitutional because it encroaches on the court's function. Even the matter of legal aid at the time that was designed pursuant to the Supreme Court rules was also an encroachment on the part of the Legal Education Board. So I agree with that observation because those are two of the observations that no less than a committee led by Justice Jose Vitug observed when they examined the charter of the Legal Education Board, Your Honor.
I do agree that the Supreme Court is better off having control over legal education.
Your Honor, as far as the Supreme Court's function is concerned, I think the rules of court have already provided the minimum requirements, no, that the court would set for admission to the bar. But legal education is, of course, something that is more expansive than mere admission to the bar per se. And for which reason, I think we also need the cooperation of other stakeholders, no, outside the court. And I'm talking about law schools, about communities, no, that rely upon legal service. And to that extent, I think the court should not consider a monopoly of legal education per se, because legal education is more expansive than the first step of admission to the bar, Your Honor.
But personally, the powers of the Legal Education Board under the Legal Education Reform Act are vague and refer mostly to periodic tasks. For example, the setting of accreditation standards and minimum standards for law admission, while some powers have already been done by the Supreme Court. MCLE and law practice internship under Rule 138 of the Rules of Court. Even as enumerated by Justice Alex Gesmundo in his dissenting opinion, the study of law is affected one way or another by the court's rule-making power. So it's better that the Legal Education Board be transferred to the Supreme Court rather than under the decks. Do you agree with that?
That has been suggested, in fact, Your Honor. And I remember that the Legal Education Board had entertained that possibility because of the closeness of the function of the Legal Education Board with the Supreme Court. No? And it may be worth their while to link up much closer to the court, considering that the subject of their monitoring would be law schools, which eventually produce the lawyers that go into practice. No? Of course, I think looking at the structure that the Judicial Academy had at one point been established, um, we will probably face some kind of restructuring if the Legal Education Board will come under the wings of the Supreme Court. Because there are other functions, I think, in legal education that, as I said, may be beyond mere monitoring of the practitioners per se. And I'm really looking at the supervision of law schools for that matter, whether the court is prepared to go into monitoring all the law schools around this country. Um, Schools also have what we call academic freedom. As institutions of higher learning, I think there is great care that institutions of higher learning take into account when it comes to the exercise of academic freedom within their respective institutions. I think these are the challenges that the court may have to consider if legal education board were to come under its wings.
And Justice Gesmundo continued that explaining that the court, which means the Supreme Court, has the exclusive power to promulgate rules for admission to the practice of law. Thus, the court prescribes specific subjects that a law school must offer before its student can be admitted for the bar. And even before the student begins his study of the law, the Supreme Court already provides the requirements for his or her pre-law studies. The precursor of Republic Act 7662, which is Department of Education Order, the DEC Order number 27, also recognizes that the Supreme Court contributes to requirements for admission in law courses. Even after earning a law degree, the Supreme Court continues to participate in the study of law. If this controlling authority took over legal education as well, perhaps law schools, Justice Gesmundo emphasized, are better directed and able to better prepare the students for the bar exams. Any observation, Dean, with respect to this opinion of Justice Gesmundo?
Yeah, with due respect to the opinion of Justice Alexander Resmundo, I think that the function of legal education goes beyond just preparation for the bar. There is much wisdom in trying to ensure that somebody passes the bar for one to be able to enter the practice of law. On the other hand, there is a multitude of opportunities right now, Your Honor, that goes beyond the mere passing of the bar. And I'm looking at the various practices that are now available to someone who is in the practice of law. The bar exam is one hurdle to consider. It's the first step going into practice, but legal education goes much further, I think, than the bar examination. And that is where I think a regulatory body may actually help in terms of having to nurture the pursuit of institutions like law schools, no, to develop their own programs in the course of these opportunities in legal education.
But there is no quarrel that the Chief Justice did not participate in this decision. All right, I hope Chief Justice is listening to this and he may add or any as to the dissent. Sorry.
I'm listening.
I'm listening. All right. That is your part, Justice. All right, then. Last two questions. Is there anything else that you would like to voluntarily disclose to the council that could affect your qualifications for the highest court of the land?
None that I know of at this point, Your Honor. I think the medical aspect was, I'm sure, something that would have gone through your probing eyes, but I explained that properly. I think my SALN also has been, I think, made public, and that is also fully explained, I think, in my letter when I was asked in the preparation of the SALN about certain aspects of my SALN. So other than that, Your Honor, I think I am quite convinced that I have given as much information to the court to consider my application to the Supreme Court.
All right, my last question, Dean. What is your worst nightmare?
I'm looking at it from
Just
yeah, be, beyond this application, Your Honor. It's I think it's the environment that we're in right now, the pandemic. No, how far this will drag into, because it affects every aspect of human life right now. Career-wise, if you're looking at it from that perspective, well, I think I think I'm comfortable with my professional career at this point. No? It's just that, of course, what's important for me at this point is be able to follow through with what I still perhaps think might be worth contributing to this country. No? So I do not see a nightmare when you refer it to the professional aspect of my application. That's something beyond. I think it's more the totality of the environment that we as a human person, human beings are into, because this has really challenged every person, including myself, on how we adapt to this kind of situation around the world.
All right, that was my last and final question, because Chief Justice is so anxious to to take part in this interview. Thank you, Dean. Good luck to your journey. I
Thank you.
hope that your nightmare will not be as that of your personal nightmare or professional one.
Thank you, Your
Thank you.
Honor.
Good luck.
Thank you, Your Honor.
Thank you, Your Honor, Judge Ilaw. The last
You're welcome.
interview did Candelaria is none other than our Chief Justice and ex-officio chairperson, Honorable Diosdado M. Peralta.
Actually, I have only one or two questions.
Good morning, Mr. Chief
Good
Justice.
morning. Good morning, Dean. No? I have only one or two questions. I've been listening from the interview every now and then. And I'm impressed with your qualifications. Not only that, I know personally the Dean because we were together in the Ateneo Law School. I think for a time you were my Dean when I was in the Ateneo Law School.
Yes, Your Honor.
It was a time that you were my Dean. And I know that you are a good administrator because you recruited me in Ateneo. When in fact, I'm not a graduate from Ateneo. Anyway, also we have been together in the Philippine Judicial Academy for a long time. I think there was a time when we attended meetings conducted by the Academic Council.
Yes, Your Honor.
Also the meetings that I presided, being the chairman of the Board of Trustees.
Yes, Your Honor.
And then one of your projects is the one that you discussed a while ago about the conferment of masteral or doctoral degrees to judges, similar to the National Defense College. No, I think
Yes.
I think that's what you were saying a while ago. So you could be a good material in the Supreme Court in so far as the educational advancement of our judges. No, and I was also listening of on the questions propounded by the Honorable Judge Ilaw about the legal education program, and he was for a while he was talking about the decisions, and that's why I did not participate. The reason I did not participate is that all the petitioners were all my co-faculty members,
UST. Yes.
the UST, especially the main petitioner, Attorney Rene Grospe.
Yeah.
Rene was my classmate. He was second in the bar exams, and he's my consultant in the office. So there is a mandatory inhibition. So I have to inhibit because he's my consultant in the office. And he's my classmate. And Oka Pimentel, I think you know him personally.
Yeah.
Oka Pimentel is also a co-faculty member in Ateneo
Yes, Your Honor.
and also in UST, and a co-bar reviewer in Ateneo in criminal law. So that's why I did not participate. So, insofar as educational program is concerned, I think you can be a good you can convince the court as to what you had proposed in the last meeting that we had in the PILJA. No? But when I was listening to the questions of Justice Ila, you were also talking about legal education program. No? Now, in the Supreme Court, we have also the Committee on Bar Matters. And
Yes,
the
Your
Bar
Honor.
Matters tackle also legal education. No? Like, I think you're familiar with the amendment of the rule that we have already allowed law students to participate in what they call the OJT programs,
Yes.
already incorporated in the rules. So,
Yes, Your Honor.
if you join the court, you can also be a good chairman of the committee. You can tackle the Committee on Bar Matters and legal education program. So, so what I'm saying is that to me you are qualified. No? But I just want to ask one question, and I think nobody asked you this question. So I will just ask you, how do you describe yourself? No? And I want to know if you are compassionate, you are strict, or you are firm. Yeah, because qualifications, when the qualifications are talked about, you are qualified. But when you come to the Supreme Court, as what you also discover sometimes in your deliberations in the Philippine Judicial Academy, there are matters that are taken up, probably a recommendation for the appointment of a lecturer, and so on. And then there are the bases. Some will say, oh, he's not qualified. Some will say, oh, pagbigyan natin yan. Anyway, compassionate. So in the Supreme Court, it will be that way. There will be some judges who are charged with offenses, diba? And there may be some cases involving laborers on the part of social justice, diba? These are laborers because of social justice. I am a constitutionalist, and therefore I'm compassionate. Whatever it is, I will side with this one because I'm compassionate. That's what I want to ask from you. How do you describe yourself? It may be a combination of the two or a combination of the three. But I just want to know how you do describe yourself, Dean.
Thank you, Mr. Chief Justice. I would like to think that compassion is a virtue that underscores one's being strict and firm. One is not exclusive of the other. One can be strict, can be firm, and yet on a very personal plane, be compassionate. By experience, Mr. Chief Justice, if I may just cite our reforms that we have been doing at the Academic Council, that's exactly one situation where compassion and strictness and firmness actually may surface. No? But I think we cannot do away with compassion. That's something that every human being, everyone, who is created in the image and likeness of God will have to be characterized. Compassion, because it is what will sustain you in whatever decisions you undertake. I can be firm with my decision. I can be strict with my decision. But if I don't have compassion, Your Honor, that will undermine my strictness and firmness. Because it is compassion that will make that firmness, that strictness acceptable by the person to whom you might be addressing a decision, whether it is retirement or separation from service or even sanctioning a person. We should not lose sight and track of compassion in every decision that we make.
Now, what about accommodation? Are you an accommodating person, Din?
Accommodation is probably more challenging because accommodation can be one translated into giving favors, Your Honor. That's something that I can be firm and strict about. I think you may have seen me in law school in the early stages before your appointment to court that I have been very firm. I know I can be very compassionate, even as simple as whether to pass a student or not. No? But when it comes to accommodation, I think I draw the line between
Yeah.
what is equitable in the long run for any community.
Okay, so that's all because all the questions that I wanted to ask have already been asked by my colleagues, and you have been on the hot seat for more than 2 hours. No, so
Yes.
thank you and good luck, Dean.
Uh, I I thank you, Mr. Chief Justice, and the
My,
rest
my,
of the members.
my daughter is extending her regards to you.
Hi, Dottie.
Yeah. Thank you. Thank you.
Thank,
That's all. Thank you. Okay.
thank you very much, Mr. Chief Justice and members of the council. I appreciate your assistance today.
Thank you.
Thank you very much, Your Honor, Chief Justice Parata. That brings to a close the public panel interview of Dean Cedric Candelaria. Thank you, and we wish you good luck, Dean Candelaria. Your Honors, that wraps up the council session this morning. We shall have a break and resume at 2 o'clock in the afternoon.
Thank you very much,
Mhm.
Attorney Capacito.